Here we go. Bond reduction hearing day. Stakes are high. A $150,000 bond stands between Simon Garza and his freedom. Can his defense team convince the judge to slash it by 2/3? Buckle up.
All right, the court is calling 2025 CR 004128, State versus Simon Alexander Garza. Can I have parties announced?
Jason Gearhead for the state, Your Honor.
Marissa Javico, Clarissa Pratt for Mr. Garza.
And are you Mr. Garza?
Yes.
All right, defense has filed a motion for a bond reduction. The bond is currently set at $150,000. They're asking that the bond be reduced to $50,000. Is there an agreement?
No, there's not.
All right. Defense, you may present whatever evidence you wish to present to the court.
Thank you, Judge. I'd just like to call my client Simon Garza.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Simon Alexander Garza.
All right, you may proceed.
Thank you, Judge. Simon, how old are you?
I'm 21.
Can you tell the judge a little bit about where you're at in your life at?
Notice this early move. The defense is humanizing Simon, education, job prospects, engagement, all aimed at painting him as stable, responsible, and deeply rooted in the community. In bond hearings, these details matter.
I just finished a clinical medical assistant program. I'm a certified medical assistant now. I was going to start my job the day after I had gotten arrested. I was also preparing to study for the EKG exam. My family's here in San Antonio. I have a fiance. I've just recently been engaged. I'm seeking to marry her soon.
Are you from San Antonio?
Yes.
And you mentioned you had gotten a job. Where was your job?
Texas San Antonio Orthopedic Group.
Arrested spontaneously, or did you turn yourself in?
I received a call and I went willingly.
So you turned yourself in?
Yeah.
Okay. And
First-time offenders usually get a little more sympathy in bond arguments. But remember, the real question isn't guilt or innocence. It's whether releasing him would be a risk to public safety or a flight risk.
have you ever been arrested before?
No, never.
Okay. And the incident that you were arrested on, when do you know when they're alleging it took place?
I believe October 13th of 2023.
2023?
Yeah.
So it's been approximately or almost 2 years, but a year and a half?
Yeah.
Okay. Have you been arrested since this incident?
I have not.
Okay. And were you arrested or told that charges were coming on the day of the scene? Or the day of the incident?
I was not.
Did you have a driver's license on that day?
Yes.
Do you still have your driver's license?
Yes.
Do you drink alcohol?
I don't.
Do you do any drugs?
I don't.
Do you have any kids?
I don't.
Okay. What family do you have here?
I have my mother, all my siblings. My father's passed away. I have all of my uncles and cousins as well.
And your fiance lives here?
Yes, my fiance and her family as well.
Okay. And if you were to get out, where would you live?
With my mother.
Okay. Is your fiance living with your mother too, or just?
She's living with her mother.
Okay. And do you know if you still have your job at the?
I was told that I'm able to reapply and work as soon as I'm available.
Okay. The current bond is set at $150,000. Are you able to make that bond?
I'm not.
Have you and your family tried to make that bond?
We've attempted.
Okay. You've called bond company?
Yeah.
Okay. Do you own a home?
I don't.
Okay. Does your fiance own a home?
She does not.
Do you have any vehicles or any other property that you could sell?
I don't.
Okay. If the judge were to reduce the bond to $50,000,
This is a pivotal moment. Defense is showing there's a realistic path to release. Judges often weigh whether the proposed bond is both meaningful and achievable.
do you think that you would be able to make that bond?
I think that'd be, yeah, I'd be able to make that.
I'll pass the witness.
Yes, sir. You stated that you had not been arrested or anything since this incident happened. On October 31st, 2023, were you pulled over for speeding 86 miles an hour in the 70?
I believe
Yeah, I'm not objective, it goes beyond the scope. A speeding ticket is not an arrest.
No, that objection will be overruled. I understand what you're saying, that it's not arrest, though.
And I'm just asking if he was stopped for that, not whether he's convicted or not. So at that time, you had a vehicle, is that correct?
it was not my wife.
Because I'm assuming that just the vehicle that you were driving on October 13th, 2023 was totaled in the incident. So after you allegedly have sped just 2 weeks after this actual incident happened, is that correct?
Judge, I'm not objective, it goes beyond the scope of a bond hearing.
Well, with regards to the speeding, so my understanding of the question, and correct me if I'm wrong, the question is whether or not he was speeding, and that speeding incident is unrelated to the facts of this case. Am I correct?
That is correct, Your Honor.
All right. So in considering bond, I have
Now, this is a big turn. The judge allows questioning about speeding just weeks after the fatal crash. Why? Because bond decisions hinge on potential danger to the community, and speeding fits into that equation.
to consider safety of the community. So with regards to his speeding and allegedly, and saying that he was going 83 miles per hour, then the court needs to hear that. So the court will hear that. I don't think it's beyond, and I'm finding that it's not beyond the scope of this. State understands that they're not to get into the facts of this case, but in regards to the speeding, the state is allowed to ask or ascertain that you have the speeding, and then this is alleged to have occurred after the speeding. So that's as far as I'll allow the state to question him about the facts of the case. You may continue.
And Judge, I'll move on. I mean, since I believe I've already presented to the court of the community's safety reasons. Now, you say you have family, probably friends here. Have you gone about trying to borrow any money? Have you gone about having any type of raising money for you to actually make this bond at all?
We have.
And how much have you raised?
I'm not sure that the actual.
Okay. And then in this current case, you're aware that you're charged with manslaughter, correct?
Yes.
And you're aware that somebody has died.
Um,
And any other assets, for instance, how do you get around, before you were arrested, how were you getting around town?
I was taking the bus for a while, and then somebody had offered me the vehicle to use.
And I'm so sorry, could you speak up a little bit so I can hear?
That way, so the judge.
I was taking the bus for a while, and then somebody had offered me a vehicle to use.
So currently you have access to vehicles or a vehicle, and you are driving here in Bear County, Texas. Not currently, obviously you're in jail, but I mean, I'm saying previous to your arrest.
Previous to my arrest, I did have limited access to the vehicle.
Okay. No further questions, John.
Just very brief follow-up. Simon, how long have you been in custody?
About a month.
Okay. And on the day of the incident, you were still on the scene when police arrived, correct?
Yes.
And in fact, you were
Strong point for the defense. He didn't run. He helped at the scene. That paints a very different picture from someone reckless and trying to escape responsibility.
assisting with the crash and the victims.
Yes, I was.
So you didn't flee the scene. Police had an opportunity to arrest you if they wanted to.
That's right.
Nothing further.
All right. Any further witnesses?
No, Judge, we rest. Just
Any other evidence, state?
Not for the state.
All right.
We would ask for the
Let the
report. Yeah,
I can make it.
you can stipulate
could-
to
Well, I can stipulate the facts. if you like. Yeah.
that.
Would you like me to? Or you can.
Judge, just for the record, this was a vehicle accident. The police, they're alleging that a red light was ran and then there was a crash. That is the totality, I believe, of the facts that you need to know if the state, yeah, no alcohol, no drugs. They didn't even do field sobriety tests. The officer put in his report that he had no suspicions that our client was under the influence. If the state has any discrepancies or anything to add to the facts.
Nothing. I mean, that's a very general rendition of the facts, obviously, right, Judge. And it's a red light, allegedly a red light that the defendant had, and that the victim and the occupants in that vehicle were turning left onto a road with a green light. And there is video of it that was shown to defense counsel this morning. And the driver of the vehicle turning the victim was the actual driver, and it was T-boned at that intersection. And again, as defense counsel did present to the court, there was no indication of alcohol use, and DWI officers were on scene.
Just so you have a general awareness of what the charges are, Judge, and then we have nothing to start from it.
Even without getting into guilt, the prosecution is reminding the judge of the severity. A red light T-bone crash caught on video. That mental image can stick and influence how much danger the court perceives.
All right, I'll hear argument.
Okay. Judge, Mr. Garza is a young kid, but he has no criminal history. He's never been arrested, not even since almost 2 years since the date of the accident. This is exactly that. It is a vehicle accident. He is not a danger to society. He is not a danger to our community. He is a nurse for all intents and purposes. He is hardworking, has family here, he's ties to the community. There's no indication that he will flee. There's no indication that he will not show up for his court date. And bond is not meant to hold somebody. It is meant to ensure that they will appear. And for that reason, he has also stated that he cannot make this bond. And we are arguing that it should be lowered because there's no reason to hold him at $150,000. It's excessive given the facts. So we're asking for $50,000.
What about the safety of the community? Because the evidence that the court has received is that previously, before this alleged offense, and I'm not taking this offense as true, but both sides have just given me a rendition of what the police report says. But prior, under questioning, he's been stopped for going 83 miles per hour. And I think state said that ended in a crash, or no?
Judge, if you may,
Yes.
I may, one, the manslaughter case that we have where he's in an accident running a red light, that is on October 13th, 2023. And then what I've got from the accused here is that on October 31st, roughly a couple weeks later or so in 2023, that's when he was not arrested, but ticketed for 83 or 86 miles an hour in a 70-mile-an-hour zone.
Okay, so do you want to address that?
Judge, we will happily agree to no driving, but I mean, people speed every day in our community. That doesn't necessarily mean they're...
Here's the clash in philosophies. Defense says everyone speeds. It's not proof of danger. Prosecution says speeding after a fatal crash. That's a pattern. This is where the judge's safety assessment.
A danger. This was one incident. If we agree to no driving any vehicles, I think there's no danger to society.
All right, state.
State's position obviously is that, I mean, it seems obvious that it is a danger to speed at any point, and it's especially after you've had a fatality accident or incident where a manslaughter is possible. Roughly 2 weeks later, you're going 86 in a 70-mile-an-hour zone. So the state's position is it is very dangerous, and that the individual has not presented that the fact that he couldn't make a $150,000 bond, but that the fact that he has possibly tried but doesn't even know how much money has been raised or not raised, Judge. That's the state's position. It's just remain at $150,000.
All right, I'll give you the final argument because it's your motion.
Thank you, Judge. Just briefly, this state is saying that this is a seriously dangerous person to our community, yet they waited 1.5 years to file this case. If he was such a danger, why wasn't he arrested sooner? There has been no incidents since the date in 2023 that have caused any concern, and he has not been a concern to the state until now.
Okay.
There is no danger, Judge, and we're asking for $50,000.
All right, so just give me a moment. I'm going to think about this. Give me like 10 minutes. You're welcome.
After a 1-hour recess, the verdict on bond is in not the $50,000 the defense wanted, but not the full $150,000 either. $1, OCA, no driving, GPS monitoring, in bond hearings. That's called a compromise. Though Simon's family might call it a stretch.
Right. We're back on the record in 2025 CR 004128, State versus Simon Alexander Garza. All right, this is going to be the court's orders with regards to the bond reduction. I am going to grant the motion to reduce the bond. I'm going to reduce the bond to $100,000, and there's to be no driving. Are there any other conditions that are requested from the state?
The state will be requesting GPS, Your Honor.
All right, there'll be a GPS. I'm going to ask that the fees be waived. They will be waived as long as he does it through the jail.
Judge, can we request partial so he can find another job?
Do you want tracking or partial?
State will do this partial.
All right, so there'll be partial for employment.
What do you think? Was the judge fair in splitting the difference, or did public safety outweigh Simon's clean record? Let's hear it in the comments.
Is there anything else?
No, Your Honor. Do you require an affidavit of Manslaughter?
Yes. All right, thank you. Ms. Ferguson, if you'll give him a reset form, please.